who an hour ago just turned my 15-year-old PowerPoint into one that actually could be played today. So thank you, Rob. He is a miracle worker. For those of you who are thinking about having some partisan talk today, this will not be partisan. Not at all. It will be political. It will be political because anything having to do with the Constitution, with the rule of law, is going to be concerned things that will perhaps have an impact maybe today. But I want you to know that while I prepared this PowerPoint 15 years ago, between the Bush and Obama administration, however, I think it may have as much relevance today as it did 15 years ago, as it did 250 years ago when our Constitution was created, and 250 years from now if our country is still around. David Souter died last month. He was a justice of the Supreme Court, and he said, "I'll start with the bottom line. I don't believe there is any problem of American politics and American public life which is more significant today than the pervasive civic ignorance of the Constitution of the United States and the structure of our government." He also said that public ignorance about how the American government works would allow an authoritarian leader to emerge and claim total power. And of course, I will be talking about King George III today. He also said that ignorant people can never remain a free people. This is the way democracy dies. Democracy cannot survive too much ignorance. That's how the Roman Republic fell. And Thomas Jefferson, who I will quote several times today, one of my favorite quotes, and he was a complicated character, but he had great quotes. Only when the people are well informed can they be trusted with their own government. Thomas Jefferson also said that a well-informed citizenry is the best defense against tyranny. If a nation expects to be ignorant and free in a state of civilization, it expects what never was and never will be. An informed citizenry is at the heart of a dynamic democracy. I said this was going to be on the rule of law. For what is the rule of law? Well, let's start with what the rule of law was defined by Thomas Paine. You all remember him. You read his short little vignette when in 1776, I think, Clark, you were a young boy then, and that it helped to establish the American Revolution. And what he said in very short words, for as in absolute governments, the king is law, so in a free country, the law ought to be king, and there ought to be no other. So before we even begin today, thank you for coming this afternoon. You have already demonstrated by your attendance that you intend to be an informed citizenry and that you will remain vigilant and unceasing in your vows to preserve our Constitution and the rule of law. All right, there are four ideals that have established our government in the United States of America. The first one is what we're going to talk about, the rule of law. The second one is separation of powers and how critical that is. Third, checks and balances, and checks and balances are incredibly important in our society. And the fourth, which I'll talk about probably mostly, is impartial courts and judges, mostly because as a judge, I know a lot more about that than I do about a lot of other things. Rule of law, let's talk about that. Law is there to regulate everybody's conduct. And we'll see. We'll get an example of that in about 2 minutes. And in the rule of law, everyone is equal. We all have the same rights. Laws are not the orders of a powerful government or the order of a king or a dictator. Okay, now I'd like to introduce to you two very important people that we brought in from a baseball game. First one is Bruce the Bomber. You can stand up, Bruce. Bruce the Bomber now is a really, really good baseball player, but he does have a temper. I'd also notice they keep standing up. Then I'd like to introduce to you Ira the umpire. Ira the umpire. Now, Ira the umpire is blind and crooked. So just like other umpires, and they are going to be watching this ball game that we're going to see in a minute. It's a very short vignette. And you can read that. And that the crowd is cheering because the Bruce the Bomber just hit a home run over the center field wall.
Foul ball.
What? What? I clearly hit through the center field and out of the park. That means that it's a home run. How can you say that's a foul?
Too bad. That's my definition of a foul.
Show me where you got your definition.
Now look, those are just my rules. I'm the umpire, so deal with it.
Okay, sit down. They're not done. They have a couple more seats, so hopefully we can get a better umpire before it's over. But again, you saw what happens to the game of baseball if we don't have rules, if we don't have somebody to make the rules and somebody to follow the rules. So we not only need to have the rules, but we have to have people who just aren't going to make up their own rules whenever they did it, like that umpire. And I want you to know that basically in 1776, in the Declaration of Independence, one of the most important things that Thomas Jefferson put when he did the Declaration of Independence was that the King George III was picking his own judges, and he would fire them if he didn't like them. If they didn't rule in favor of the crown, he would reduce their pay, get rid of them, do a lot of things. So what we did is we started a war. We started a war that lasted 8 years and killed thousands and thousands of people, just so we could have the opportunity to have a free country with the rule of law. And that's what this country was founded upon. We have the rules, not in our rule book of the rules of baseball, but in the Constitution. And in the Constitution, we have speedy jury trials, other rights, and also, most important of all, our Constitution was set up in a way that we were terrified about monarchs. We had George III to be afraid of, and we were terrified that we'd have another one. And so that they made the writers of the Constitution, Adams and Jefferson and all the rest of them, they were made sure that they put into the Constitution lots of protections against having a tyrant take over. And so what they did is they separated the government. They separated the government into 3 different places: the legislative, executive, and judicial. This wasn't the first time that there was a discussion of the 3 branches of government. Montesquieu in the 1600s said that really we need to have a king. That was not a problem. But we got to have 2 other organizations, 2 other entities that are just as important as the king. And the king being, of course, the executive. We'd have to have a legislative, somebody to create the laws, and then a judiciary, somebody to figure out what the laws were all about. And every branch of government is equal. One branch is not the head. It was so critical to the founders of this country that the king would not be the over and above all other things. In that case, the parliament and any judges that they might have had in the country. And also, if you have the right to do something as a legislature, then you have the right to do that, and the king cannot take over that, or in this case, the president cannot take over that. Checks and balances. One of the brilliant things that we put into our Constitution was not only that each of the branches had a different power, but that each of the branches could check one of the other branches if they did something wrong. It was incredible that that was thought of. That was, again, one of the ideas of Montesquieu in the 1600s. He said you had to have checks on them. And then we're going to come to our first video now, but let me explain it to you. First of all, it's going to be pretty loud, but it's going to be loud because this guy talks faster than I do. And so it's going to be, but I'll even tell you what the first joke is going to be. A president and a congressperson and a judge walk into a bar. And the bartender says, separate checks. Oh my gosh, it's a good group, you got it. Okay. So anyway, you're going to hear that, and then it's going to go into a little bit of a kind of a video about how the checks and balances work. So here it goes.
So, what are the real branches of power? Here's a hint. President, senator, and judge walk into a bar. Bartender looks up expectantly and asks, separate check? You see, our Constitution separates the federal government into three independent but overlapping branches: executive, legislative, and judicial. Here's an example of how it works. The legislative branch, Congress, is empowered to pass bills into law. The executive branch, the president, can check Congress by vetoing a bill. Congress, in turn, can check the president by overriding the veto by a two-thirds vote. The judicial branch, in this case the Supreme Court, can check Congress and the president by declaring the law unconstitutional. And Congress, in turn, can change the Constitution to the amendment power. When it comes to the judicial branch, the Constitution stipulates that federal judges will be appointed by the executive and legislative branches rather than elected by American voters. Think about it. How can federal judges remain independent and impartial if they have to bow to political and popular pressures to get elected? John Marshall, the Supreme Court Justice from 1801 to 1835, said, "The greatest scourge an angry heaven ever inflicted upon an ungrateful and a sinning people was an ignorant, a corrupt, or a dependent judiciary."
And I'll be getting onto the concept of a dependent judiciary, meaning a judiciary that is not basing its decisions on the rule of law and of the facts of the case, but it's basing its decisions on money, on power, on somebody telling them what to do. The independent judiciary is the most important thing that protects all of us today. The fact that I was part of the independent judiciary has nothing to do with that. And the only thing we can consider as judges is the law, just like an umpire would only consider the rules. We can't consider personal gain, prejudices, preferences, and I'm going to have a slide that gets to that more clearly in a minute. And again, the umpire, even a crooked umpire like the one we have, cannot make a ruling in favor of the team that happens to be his or her favorite. Okay, Bruce the batter, he just hits another home run. Because Bruce the batter, I told you, is a really good batter. And he just hit another home run. Unfortunately, we still have Ira the umpire. Please stand up.
Foul ball.
Not again. Are you blind? That was totally a home run. And this time, I have the official rules to prove it.
The rules? Huh. That doesn't matter because it's my call.
But you have to follow the rules. You can't just make calls for other reasons.
Well, I have some pretty good reasons. In fact, I have about 2,000 green reasons that the visiting team gave me before the game.
How is that fair? You got paid by the other team to make that dumb call. No matter how I play, you'll never let me score.
Okay, thank you. Sit down. Great job again. But they're going to come back for one more time. Hopefully, well, we'll see what happens. If there's one slide in this entire package that means everything to me regarding the concept of judges and other persons in the triumvirate, this is it. If you are a member of the legislature, or you are an executive, meaning if you are the president or a governor, if you're a member of one of the houses, you must consider your own political party. because they're the ones that got you there. You must consider special interests, because they're the ones that possibly gave you money in order to get elected. You must consider what the voters did. In fact, the voters put you into office, so you better consider them. And you must consider and you can consider your personal preferences. Meaning, if you have a desire to do something, you're even going to campaign on that. I think we ought to do this, and vote for me, and I'll do it. However, if we change that to judges, judges cannot consider what the rules are of their political party. They may not. They cannot consider any special interest. They cannot consider what the voters did to them, even if they voted them into office. They cannot consider what the voters might want, and we'll get into a couple examples of that in a minute. And they cannot consider the personal preferences. Think about that. Judges cannot have a personal preference that affects the ruling that they make in a court. It has to only be the rule of law and the facts as entered into that. Critical, and that's what keeps us free as a country. Now again, we do everything, we make decisions on the law based upon not just the Constitution, but the parts of the Constitution that treats everybody equally. The 14th Amendment, the other amendments that say everybody has to be treated equally. Otherwise, we could be ruled by anybody who wanted to make a ruling that is in favor of, I'm Polish people, maybe that'd be okay, but all right. And we can't be influenced by public opinion. Some of you know that in 1954, the case Brown versus Board of Education was decided, and it made the ruling that black and white children, before that, had to attend separate schools. And here's an important thing to remember. In 1954, the vast majority of the country were in favor of segregated schools. And in fact, this is Brown versus Board in Topeka. Topeka, Kansas was totally in favor of segregated schools. And the judge in Topeka, Kansas made the ruling that that was unconstitutional. It eventually got up to the Supreme Court. There's a history of how the court had to decide that and made the decision that they were going to not only say that separate schools were inherently unequal, but that they made it a 9-0 vote so that it could all be on the same side. But I want you to know that the judge who made the ruling at the beginning, and of course the judges on the Supreme Court, they were not following what the country wanted. At that point, the majority of the country would have said, keep schools segregated. But judges are different. We don't do things because people want it. Just another example of that, for those of you, Jehovah's Witnesses were not permitted to salute the flag. And so that their case came up to the Supreme Court, and the Supreme Court basically said that it was unconstitutional to force this group to do something that was against their religious beliefs. And as Justice Robert Jackson said, the purpose of the Bill of Rights was to allow certain subjects to be free from political controversy, to place them beyond the reach of majorities, officials, and to establish them as legal principles to be applied by the courts. And then, of course, every religion, this is Thomas Jefferson, I told you I liked him. Every religious society has a right to determine for itself the times for religious exercises and the objects proper for them according to their own particular tenets. And this right can never be safer than in their own hands, where the Constitution has deposited it. A little old there, but a couple of those people are still around. So what about judges? Judges don't write any laws. You might not think that, but judges don't write laws. We only we only interpret them. Just like the umpires are not supposed to, maybe this one is different. He's not supposed to make up the rules. This one did, but he's crooked, but we know that. And judges have to make rulings based upon things that they may not personally think are right. There are a number of cases during the course of my 25 years on the bench where I had to make a ruling that I didn't really like that law and I wish there were a different law. But again, if the law is not good, it's up to the legislature to change the law, not judges. Judges don't change the law. And again, I'm talking about basically the trial court level and the appellate court level, the first appellate court level. Now, is there something that does control judges? Yes. We have our code of judicial ethics. We've already talked about some of the things that we can do and things that we cannot do. And we have to do that. So that, for instance, if Rita comes before my court, I would not rule against her immediately. No. If you have a friend or family member comes before you, you can't hear that case because you can't possibly be unbiased. And that's just kind of something that we know in our hearts, and as a result of that, we're not going to permit it. And this is, I love this one. Judges cannot state their opinions on matters that they may hear. So here's my thought for you. Somebody is running for judge, and they say, I don't like drunk drivers, and you don't either. So the judge says, I promise you, if I get elected, every single drunk driver that comes before me, I'm going to throw in jail for 6 months no matter what. And you go, yes, and you vote for that judge. And once that judge gets in office, he can never hear that kind of a case again. Because he has already indicated that he's biased and is not able to make a decision that is based upon the law and the facts. He or she is going to make a ruling that's based upon that personal preference. Remember I said you can't have personal preferences, and that you have to base everything on the rule of law. And of course, we're not allowed to accept personal gifts. If anybody has a tip after this, I'll be allowed to. But again, we have to make sure that this umpire, treats everything good. This is a real advertisement from the year 2000.
I wonder why families never get a fair shake from the Michigan Supreme Court.
Bill, where are my judges?
Just where they've always been, right in your pocket.
Pretty nasty example, but again, that's what was being advertised in the year 2000, 25 years ago. And it still is something that people are accused of today, and that is that people, some judges are in the pockets of powerful people or rich people. Now, is there future? Well, let me tell you, the Justice Sandra Day O'Connor, who by the way passed away this, I think a year and a half ago, has been pushing to have more and more organizations do exactly what we're doing here today. Talk about the Constitution, talk about the rule of law, talk about impartial judiciary. And that we, as she said, we must be ever vigilant against those who would strong-arm the judiciary into adopting their preferred policies. We can't have people forcing the judges to make decisions that they want and not decisions that are based upon facts, the law, and the Constitution. The founders realized that there has to be some place where being right is more important than being popular or being powerful, and where fairness trumps strength. And in our country, that place is supposed to be the courtroom. That's where you're going to get it. Now, have there been attempts to contradict the power of the judiciary? Yeah, in South Dakota about 15 years ago when I was producing this PowerPoint, there was a proposition, a statewide proposition, that said that if a judge made a ruling that people disagreed with, they just disagreed with the ruling, not that it was wrong on the Constitution or the facts, but they disagreed with it, then they could be sent to jail. Now, the good news is, I'll tell you the story because it's 15 years later, the initiative did not pass. It died pretty badly. But there were people who thought that it would be important to be able to put judges in jail if in fact they made decisions that you disagreed with or that they disagreed with. And this is the one that I'm most concerned about, or was most concerned about, and I have a trick question for you after this. Judge Lauren McMaster made a decision in Sacramento when I was the presiding judge there. And the decision he made, he was asked, is it constitutional for a same-sex couple to get married? Is it constitutional for them to get married? He made the ruling that it was not unconstitutional, meaning it was okay with the Constitution. Immediately, there became a group that rose up that started advertising that they were going to recall the judge, and that if any court of appeal affirmed that, they'd recall everybody that affirmed the judge too. So again, remember what was going on. They wanted to recall this judge and kick him off the bench because they did not think that same-sex couples should be married. So here's the trick question. What was Judge Lauren McMaster's personal opinion about same-sex marriage?
He didn't like it.
Wrong. The trick, I told you it was a quick question, but thank you, you're perfect. The answer was, it's irrelevant. It's irrelevant what he thought because his personal opinion is not supposed to enter into the decision of whether it's constitutional. They were asking him, does this Constitution of the state of California prohibit people from same-sex people from getting married? And he said, no, I looked through that and it didn't. And by the way, the Court of Appeal also affirmed it. And the good news was, out of they needed 35,000 votes, and I spoke throughout the state of California on this in order to try to make sure people understood what was going on. And it failed miserably. They were to get 35,000 votes, and they got 7. So the guy's still on the bench until he passed away a couple of years ago. But the important thing is, if you're going to criticize a judge, and I'm going to show you how you can, that's okay. We can take it. We got thick skins. But criticize us based upon the legal ruling that we made that is inconsistent with either the law or the statutes. Don't criticize us because by this ruling, I'm probably a terrorist. Or by this ruling, I should be thrown off because I'm terrible or I'm dumb or whatever. I may be that, but at least I may have followed the law. Okay, now, can judges be questioned? Oh yeah, absolutely. There is a way. The first way, of course, is the one that's pretty obvious to all of us, and that is the instant replay. Any decision that a trial court judge makes can be reviewed by a court of appeal. So anything that I say here is law until Don King gets a hold of it, because he was on the court of appeal. And he could say, Jim, you're wrong. But if he did that, he wouldn't say because he has a personal opinion about it. He would say, I'm wrong because I misread the Constitution, I misread the statute, I misread somehow egregiously the facts. And so there we have that. And how many other areas of your life or anything is there a court of appeal that's going to immediately make a decision about about something that you've done and then to reverse it? Because judges, John King reversed many things over the course of his illustrious career. Fortunately, I wasn't in his district. Otherwise, he would have been reversing me all the time. Anyway. And also, we have something called the Commission on Judicial Performance. And basically, that's a group of people who are not judges. There's a couple of judges on the commission, but most of them are lay people. And they review things that judges do. Mostly, they're going to look for judges who are drinking on the job, who are coming in late, who are having their cases sit for too long and not deciding them fast enough. And if they find that that's true, they can remove us. They can say, you're out of here, Jim, or they can sanction us. They can do a letter that says publicly admonish us. So there are things that will protect judges, protect people from judges who make bad rulings.
Next case.
The People versus Martin White. Mr. White has been charged.
Guilty. Next case.
But Your Honor, you haven't heard the charges yet.
Next case. Guilty. United States President. Guilty.
So Bruce the Bomber hits another home run over the center field fence. Stand up, folks, this is your last chance. And Ira, the umpire, says,
It's a home run.
How cool, that's actually fair.
Well, duh. Look, I'm not trying to be cool. I'm following the rules and being impartial.
can we give a hand to Bruce the Bomber and Ira, the crooked umpires who now have seen the light? It's a simple thought. If we can't even play a baseball game without following rigidly the rules of the baseball game, how can we have a country that does not follow the rule of law and all of the other things that we spoke about today? I'm going to have a couple of closing thoughts. You know, as I said, I like quotes. And if you remember that in our experiment with democracy, when the Constitution was written, a woman asked Benjamin Franklin, well, what have we created, Mr. Franklin? And he answered, a republic, if we can keep it. So, some of you might ask whether I'm optimistic or pessimistic. And some of you may not ask, but I'm going to answer anyway. I'm optimistic because of 3 checks in our country that were not mentioned here. There are 3 more checks we have. The first, we did kind of mention a little bit, and that is the lower court system. That's the judges on the trial level and the appellate level. I'm focusing on that because when things are happening and decisions are made, they're not made by the Supreme Court. Many are, many very important ones. But the Supreme Court hears less than 1% of all the cases that are decided in the country. In other words, something like thousands of cases are decided every year that never get to the Supreme Court because they end at the trial court level. And if most trial court judges, and I will say this absolutely firmly, most trial court judges care about the rule of law, and they care about being fair, and they care about making decisions not based upon their own beliefs, but based upon the due process, etc., like that. There's a second reason, and that's what we call, of course, the fourth estate. That's it used to be newspapers, but it's now the free press, newspapers, broadcasts. I think it's absolutely critical that we have a free press that can say anything, even wrong things. Again, you said the solution to bad press is more press. The solution to bad ideas is more ideas. Thomas Jefferson, again, he says, were it left to me to decide whether we should have a government without newspapers or newspapers without a government, I should not hesitate for a moment, prefer the latter. Newspapers without government. Okay. Then the third reason why I think I'm optimistic about the future is you. So long as there are good folks who are trying to do the right thing, who try to understand the essence and the foundation of the principles that make this country great, we will eventually prevail. Thomas Jefferson said that one person with courage is a majority. That does not mean it won't be painful. It does not mean that we will not experience suffering. For instance, at the end of the Civil War, we had millions of people killed, but at the end of the time we had a union. We had gruesome Jim Crow for many, many years. But at least now we are trying to make sure that people are dealt with equally. Another way to get to this point is no pain, no gain. No pain, no gain. And in fact, Winston Churchill has one of my favorite quotes of all time. And he said that Americans, that's us, can always be trusted to do the right thing once all other possibilities have been exhausted. So we're going to get there, but it's going to be battered and we're going to be bruised and bandaged. But when it's at our best, our republic, our rule of law is worth the battle. And to close, show that Thomas Jefferson did have a sense of humor, because I'm getting too serious with him. He also said something that's appropriate for us here at Verena, when he said, "We never repent of having eaten too little." So to close, I'd like to recite the very brief second half of the second verse of the song America the Beautiful, which I think should be our national anthem. It doesn't glorify war and rockets red glaring and arrogant pride. The song America recognizes that we are not perfect, but we are trying to better ourselves by working from within, not by hurting other people, not by mindless braggadocio, and finally that we rely upon the rule of law. And if you recall, the last section of the second verse is, America, America, God mend thine every flaw, confirm thy soul in self-control, and thy liberty in law. Thank you for coming this afternoon, but especially thank you for being a critical part of the solution, because you choose to be educated and not blissfully ignorant and dangerously ignorant. And you are the courageous bulwark against the destruction of our democracy and thus our entire society. Thank you. We have a few minutes, and I will not answer any partisan questions, although you may have seen something here. Anyway, yes, okay, stand up. We'll get you a mic.
I can yell.
No. Yeah, then you'd be like Arba. No, you'd be like Bruce.
Today I'm more concerned about enforcement than I am the courts. The courts seem to be doing okay. But when criminals at a certain level ignore the courts, what power do the courts have to enforce the laws and put the criminals in jail?
Okay.
You know what we're talking about.
Okay, well, I'm going to handle it from a 5,000-foot level. First of all, a couple of things that would always bring up, and that is that courts don't enforce anything. The executive enforces. The cops enforce. They're part of the executive branch, not the judicial branch. The judicial branch, they just interpret the law to see if a person is guilty, innocent, etc. And the other thing that's really important for us to remember, and particularly those of us who may be discouraged now or 15 years ago or whatever, is that courts are slow. And I like that. Because we don't make decisions in 2 seconds about what things ought to happen. We think about them, we ask both sides. It's called due process. It's called people, you tell me your side of the story, you tell me your side of the story. Let me think about it. Let me give it to my associates. Let me read some books and figure out, and then we'll make some rulings. So courts are not there enforcing anything. The courts are there to interpret what's the right thing to do based upon the Constitution, the laws of the land, and the facts of the case. Let's see. Let me get, right here first.
So impartiality is the theme that runs through all of this. Can you imagine artificial intelligence becoming part of the judiciary in the future?
Well, I think that artificial intelligence is going to be part of our future. We don't have a choice of that. I mean, it is going to be there either to help us drive our cars or to help us anything. The difficulty, of course, is when you substitute 100% AI instead of having AI maybe look over something that you're doing just to see if there's any gross errors in it, and then checking those errors themselves. There are a bunch of attorneys who have already submitted briefs to judges that had citations that were not there, that didn't exist, cases that did not exist. That's called, in the AI world, that's called hallucinating. That AI can hallucinate if it's trying to make a point somehow. So it'll pick a court, and they'll give the name of the case and the citation and all, and something that doesn't exist at all. That attorney did not do very well in that case, because judges read cases. And if a judge ever got to the point where he or she were, using AI to make a decision in the case, that would be the Commission on Judicial Performance to do something about that person very quickly. Thank you. Thank you, Rob, again. He's always good.
Do you think it would be advantageous to have term limits for Supreme Court judges?
Okay, that's going to be a political question. I won't get into that, but if anybody wants to have dinner with Reed and I, I'll be happy to chat about anything that you want to chat about. But as I said before, I think that might get beyond what I'm doing here, because what I want here, nothing that I've said here anybody should disagree with, because these are things that are essential to the existence of our country and our future and our rule of law. And as a result of that, we can go away from here and then make your own decisions about how the kinds of things I would do it. And that's one of the questions that could have to be answered. Yes, Dick.
So Jim, thanks for speaking tonight. So now you're a California Superior Court judge in LA. And because of good reason, you've subpoenaed a witness to appear in your court. And that witness has shown up, and your trial is underway, and in from the back of the courtroom burst 6 ICE agents, and they want to handcuff your defendant. What would you, as the Superior Court judge for the state of California, do in this case? And then secondly, would your answer change if you were a federal Superior Court judge?
Yeah, and the answer to that question would be have dinner with Reed and I and for a long time.
Good question.
Bruce.
I'd like to be in that dinner.
So, I'd like your opinion on the election of judges. Sometimes I get this, when it's time to cast our votes, I get this roster of judges. I don't know any of them, and I wish somebody else would pick out.
Yeah, now that's a good question, and I'll try to adjust that one. You saw that in the federal system, they said that we're not going to have elections of judges. You saw that in the first video. And that's because we didn't want judges to be dependent upon one party or the other, or one action group or the other, and so that they're appointed. In California, 95% of judges are appointed by the governor, and then some percentage run on their own. And then once you're appointed, you do have to stand for re-election every 6 years. But good news, bad news is that nobody really knows us. So I've stood for election 3 times. No one ran against me, so I wasn't on the ballot at all. So that's probably maybe not really good. But on the other hand, federal judges have lifetime appointments, and they are not replaced by anybody after a certain period of time. They can be on for life, and that's good and bad. It's bad if you don't have a very good judge, but it's really, really good if you're the judge in Kansas and you had to decide Brown versus Board of Education, and all of your neighbors were going to say, if you decide for integrated schools, we're going to kick you out of our country club and you're not going to come and play bridge with us on Saturday night. And not only that, but we're going to write the people upstairs and try to get you eliminated as a judge. That won't happen, because the good news is, at least from a federal standpoint, they have lifetime appointments. Are there things that can or should be done? Maybe, but I think we're getting into the 95th percentile of what kinds of things can we do to make a more perfect union at that time. Yes?
Yeah. Again, thank you, Jim, for a wonderful presentation. I really enjoyed it. My question is, sometime on the presentation, you mentioned that there is a commission that reviews judges.
Yes, Commission on Judicial Performance.
That's civilian.
That's what?
Civilian. They're civil. They're just. They're
Yeah,
not
there
judges.
are
They're
2 or 3 judges on the commission, but there are about 5 or 6 or 7 people who are not judges on the commission.
Does such a thing exist for the Supreme Court?
No. That's the only comment I'll make about the Supreme Court.
Nothing. So there's nothing on a federal level?
There's nothing on the federal level that can review the Supreme Court for making decisions that might be problematic on a scale that is not just a decision about whether it's constitutional or not. we can get into that, but you're gonna have to have dinner with us for that.
Jim, I've always been confused. Could you give us an example of how many levels of judiciary or judges there are? It seems so many different levels. Could you elaborate on that for me?
Great question. And the good news is that both on the state and the federal level, there are 3 levels. I'm a trial judge. I hear all the cases on the lower level. If it's a criminal case, if it's a burglary, if it's a divorce, I will hear that case. Then there is one appellate level, and that is the Court of Appeal, which Don King was on, is on really in a way, because you never leave it. And there are, help me, there's 6 courts of appeal in California, and each one has anywhere from 4 or 5 to 15 judges, and they divide up the cases. And then there is the Supreme Court of the state of California, which has 7 people on it, and that's the ultimate ruling. And like the federal, they don't hear everything because they can't possibly do it. That's what the courts of appeal are for. In the federal level, there is a federal level that is the trial courts also. There's the courts of appeal on the circuit courts of appeal, and there's I think 9 or 10 of those. And then there's the Supreme Court, which has 9 people on it. Don, did you want to say something?
Mid-level people are sitting in panels.
Okay, there may be 6 or 7, there may be 10 or 12 people in a court, like in a appellate court, but they will sit in terms of 3 judges making decisions about the cases. So all the people in the Court of Appeal, a particular Court of Appeal, will not hear all of the cases. They divide them up.
Thank you.
Yeah, since your presentation started with the importance of the great Constitution, my question is related to that. It's extremely built into the Constitution that it's extremely difficult to change anything in the Constitution. And we've had, a couple of examples of that over 200 plus years, starting maybe with the rights of women to vote and so forth. But it's very difficult. Do you think that anything ought to change a little bit after 250 plus years to do that?
There are a lot of people who are saying exactly that. We should have a new constitutional convention. And a new constitutional convention, of course, would create a new constitution. It would create different rules. The good news about that is we can get rid of some of the bad things about our current constitution. The bad news about that is we might lose some of the things in our constitution that are good. Do we want to eliminate the checks and balances? Do we want to eliminate some of the other things that are in it? It's a very, very good question. Won't be answered tomorrow, but it's one that we can continue to have. And to the extent that one of us has some good ideas and starts writing about it and producing some thoughts about it, then we might get to the point where there may be a desire to actually change a portion of the Constitution. Let's have maybe one more and to tie it up. Okay. Janet, okay. Well, Janet, we'll do 2 more because they both raised their hand. Janet first and then you.
What can we do as a average citizen to change what's happening?
Okay, with respect to changing anything, all I'm going to talk about is the fact that you need to be educated. You have already done 99% of what needs to be done, and that is to know how the system works so that when people come and tell you something and say something to you, you'll be able to say, no, that's not it. You're saying that this lady right here. No, well, okay, that's fine. And so that it's really important when you're in conversations and somebody says this judge ought to be eliminated because he voted for to have same-sex couples be married, and I'm against that because I think that's not permitted by the Bible or whatever. You can say, wait a minute. What was the decision the judge made? The decision the judge made was it constitutional? So anytime you hear anybody criticizing a judge, make sure that they're not saying they're terrorists, they're terrible, they're drug, they're make sure that they are making the argument that Based on the Constitution, they should have followed this measure of the Constitution or this law rather than something else. If they are not doing that, they're using a rhetorical argument that is a fallacy, because it's not an argument against that judge's ruling. It's an argument, it's an ad hominem argument. They're arguing against the person and not the argument itself.
I had a question about your trial. You were on the trial area?
Yeah, I'm a trial court judge, yes.
And once an opinion or a decision is made on the trial level, then suppose it goes up to the appeal level.
It can if the parties choose to do so. It doesn't automatically go up.
Well, often you will hear about a controversial case in which the appeal has been thrown out. Among the appeal judges, do they read each other's opinions and make a decision together, or how is that?
Among the different courts, for instance, if it went to Don King's court in the first district, which is San Francisco, there would be a panel selected for that case, and that panel has 3 people in it, and they would make a decision. Now, whether they talk to other people, you'd have to ask Don about that, about whether they talk to other people about, what they should do in that particular case. But for the most part, that's the 3 that make that decision. Okay, thank you all very much. You're wonderful.